Ladies and gentlemen, welcome back to the last session of today's conference, the second plenary session, in fact, under the header Enhancing Coherence in Strict Liability. We have a panel of very distinguished speakers tonight. Before we start, allow me to repeat some of the applicable housekeeping rules. Each speaker will have 20 minutes, and I will have to interrupt if anybody overruns, simply because we are already late in the day. If the panel, if anybody has questions, please chat them in to me or to Vivian Tsui so that I can ask them during the Q&A session. We will have one Q&A session at the end, combining all the the questions regarding the presentations. We start with Professor Rick Glowczewski, an old friend of ours. He is a professor at the Faculty of Law of Hong Kong U, University of Hong Kong. His primary areas of teaching and research are tort law, labor law, and of course he is a legal education expert. He is also the editor-in-chief of the Hong Kong Law Journal. He has published broadly on various topics. Amongst others, he's the author of Tort Law in Hong Kong, published by Sweet and Maxwell in the 4th edition. His topic today is vicarious liability reform in Hong Kong. Rick, over to you, please. You are still muted. You are muted. You need to unmute yourself, please.
Thank you so much for the very kind introduction. Now I'm going to do what I am often not that successful at, and that is to share screen. This should be it. How does that look? Is that this? Oh, sorry, I'm on the last screen, but
yeah, it looks good, except that you are at the conclusion. You need to move up to the first slide.
I usually prefer to begin with the conclusion and then see.
That's fine.
See whether everyone will agree with me, but I think I'm on the first slide now. Thanks.
Over to you.
Yes, and thank you all, Dean and also Norman, for inviting me to participate in this conference and to speak to all of you. And also, I want to thank your administrators, particularly Ellen Poon, who has been marvelous at keeping me informed as a chairperson of what was going on. So thanks to her and all of your team. So the topic or the theme of the conference is tort law reform in Asia and beyond. And specifically for me, I'm concerned about tort law reform in Hong Kong and more specifically about vicarious liability reform. But I would begin by noting that in Hong Kong, there have been no statutory interventions into tort law in more than 3 decades. And this is unusual if we recall what some of the earlier speakers referred to by way of legislation in Singapore and in Australia, in New Zealand, and in the UK, various examples of it. I think in Singapore, there have been 4 statutory interventions into tort law in the last 8 years alone. We've not had any. So in Hong Kong, any hope for reform of tort law, or perhaps any area of the law, is dependent on the courts, on development of the law in the courts. And this is often a very successful process, but often equally perhaps not. And we can evaluate whether that has been the case with vicarious liability. I note from the speakers' comments from the first plenary session that they have their own doubts about the success or the effectiveness of achieving tort law reform through legislation. So we should bear that in mind. Perhaps Hong Kong is doing the right thing by avoiding statutory attempts at reform. But I think we'll see that the development or the reform of the law through the case law is cumbersome, produces often uneven results, often with unintended consequences. And I think this is particularly so when the developments or the reforms are adopted from abroad as opposed to developed from within. And I think vicarious liability is an example of that. So today, my objectives are modest, and I'm quite sure that I will stay within the 20-minute speaking time without any difficulty, hopefully leaving time for questions later on. So my objectives are to provide an update, first of all, on vicarious liability in Hong Kong. There have been changes, and they may be familiar to many of you, but perhaps not all of you. I have some questions around the theme of vicarious liability, and that, for instance, what has triggered the changes that have taken place? Were they necessary? What are the consequences of these changes? It's important to recall that and as tort scholars, probably very familiar to most, if not all of you, that vicarious liability historically has consisted of two limbs. Employers' vicarious liability required the proof of a contract of employment, first of all, and then that the tort committed by the employee was committed in the course of the employment. So if we recall, this is probably you're teaching this the past semester for all I know, that the contract of employment requirement was determined by the common law, certain common law criteria, rather flexible, determining whether or not there was a contract of employment in any given case, and it's a very fact-sensitive determination. And then that the tort is committed in the course of the employment, and we're all familiar with the famous Salmond formula, which said that the tort would be committed in the course of employment if it was even an unauthorized mode, so long as it was the employee was carrying out an authorized task. It's an awkward formulation, but we've lived with it for perhaps almost a century or more than a century. Now, the reforms that I am going to refer to concern both limbs, the contract of employment and the course of employment. But here, it's important to consider the context in which these reforms were introduced. In the reforms, the Hong Kong reforms really are adopted from UK case law from the House of Lords and the Supreme Court. The context is the sexual abuse of children by caregivers or teachers that were employed by the defendant. Now, it's easily understood that this kind of tortious conduct does not fit that well within the conventional conditions for vicarious liability. In particular, the second limb. It's hard to imagine how such conduct could be in any way seen as a performance of employment task, even an unauthorized performance of an employment task, because employees are not hired to do such things. And for that reason, it's understandable that reform was required, and it was introduced in the UK. So I'll speak about the second limb at this moment. First of all, that particular social problem required a solution if compensation was going to be made available to victims of that kind of conduct. And so the change to the law of vicarious liability, the second limb, came in the Lister decision in 2001. And this, of course, provided a remedy in an important area, but it is a restatement of the law, so it has application beyond that context. And we can see how the growth of that tort, of that limb, of that flexibility after that. Regarding the first limb, some years later, also in the context of sexual abuse of students by in this case, the various claimants' case, by Christian brothers who were teachers, not employed teachers as such, but teachers of the students, we see the introduction of flexibility regarding the requirement for a contract of employment. After this case, it would be sufficient to establish that there was a relationship analogous to or akin to employment. Of course, this is just a general formulation. The Supreme Court provided some guidance as to when such a relationship would be established. And one has to look at the case law closely to see how that has changed with successive Supreme Court decisions. But suffice it to say that after this reform or this development, it was possible for a vicarious liability to be established in the absence of a conventional employment relationship. The development went so far as to include, as a person in a relationship akin to employment, a prisoner. Now, a prisoner, of course, is not employed in a conventional sense, but the prisoner is doing work, and the prisoner in the course of the work has injured another person. That was the Cox decision in 2016. And carrying on, in the Army's decision in 2017, foster parents were found to be in a relationship akin to employment in relation to the government authority that had placed them as foster, had placed children with them in their role as foster parents. So we see this considerable change being brought about through the English case law in the highest courts there. So my question now is, how has this played out in Hong Kong? A concern of mine is how reform or development of the law takes place when it is generated by case law developments from overseas, as opposed to case law developments from within the jurisdiction itself. So we can have a look at how this has played out in Hong Kong in the general way. And firstly, I will look at the first limb of the vicarious liability conditions, that is the requirement for an employment relationship. Again, historically, this meant a contract of employment as understood at common law. And in Hong Kong, that issue is a frequently litigated issue, mainly in the context of cases involving workplace safety or work employee benefits, because of course it's in order to obtain statutory compensation for work-related injury in Hong Kong, one must be in a contract of employment, and in order to qualify for benefits under the employment ordinance, one must be in a contract of employment. So we have a lot of case law there, but it doesn't necessarily apply to the requirement for a contract of employment in vicarious liability. Certainly, we didn't see much litigation in Hong Kong in the context of vicarious liability. The cases simply didn't come before the courts. Now, after the introduction of these reforms or these developments in the UK case law, we see in Hong Kong, first of all, an increase in litigation of the employment relationship issue in the context of vicarious liability. We hadn't seen that previously. In fact, we have very, very few cases on vicarious liability in the Hong Kong case law prior to 2002. And so my point here is that an impact of the reform is more litigation. And we might ask, why is that? Is it because the scope of has been expanded and there's more scope for relief, for a remedy, or is it for some other reason, for instance, uncertainty in the law? In the UK, we see, as I've just cited, examples where relationships which don't really look like employment were found to be akin to employment, and vicarious liability was imposed. To date, we haven't had such cases in Hong Kong. We've not really ever had a successful vicarious liability case that did not involve an employment relationship as conventionally understood. But these developments triggered an increase in litigation because the plaintiffs, the victims, wanted to try on the argument. There was, of course, an open invitation to do so because of the developments in the UK. So we see that. And interestingly, many of the cases in which this argument was tried on concerned independent contractors. That is where the plaintiff was claiming that the defendant's independent contractor, that the defendant should be vicariously liable for his independent contractor's torts. Here, all of the cases in Hong Kong, 4 or 5 of them were unsuccessful in making this argument. I've summarized one of the cases on the screen, which shows you how the argument comes about. And in Hong Kong, as in the UK, the court has drawn a line underneath independent contractor. It takes the view that if the argument is being made that the defendant should be vicariously liable for torts committed by an independent contractor or his employee, that would be going too far. It would render obsolete the distinction between an employee and an independent contractor. And that's where the law in Hong Kong sits today, also in the UK, although I question that position. To draw the line in such a strict way strikes me as really not the right way to go. We have examples here and elsewhere where arrangements, where a business arrangement is such that what was formerly would look like an employment relationship is somehow transformed into one that is now an independent contractor, but the same business activity is being carried on. And I think that the Ho Kwok K case is such an example. The negligent driver in the Ho case had previously been employed directly by the defendant, but through the defendant's reorganization, subcontracting the driving to the third defendant who hired the same driver, then you can see that it's really the same operation underway, but under a different organization, and the court found no vicarious liability because it thought that would be going too far. But I'll leave that. What is maybe of greater sort of more dramatic interest is how far this argument might be carried, how far one might go in finding a relationship akin to employment. And we have these examples in Hong Kong, which show how far that argument may go, and the possibilities for the argument now that we have accepted the principle of relationship akin to employment. So I cite 2 cases here, both involving the sexual assault of live-in migrant domestic workers. And as most of you will know, there are 300,000 or 400,000 migrant domestic workers in Hong Kong at any given time, and they're required to live with their employers. Now, the argument being made here, which is rather surprising, is that the spousal relationship could be one that is akin to employment. That sounds like a very outdated sort of argument, but it was made, and the argument was taken seriously by the court in both cases. In the first case, Walia, it was an action, or a claim brought under the sex discrimination ordinance for pregnancy discrimination. The employer's wife, the employer's spouse, had subjected the migrant domestic worker to a humiliating form of pregnancy test, and then she was dismissed. So in bringing her action under this sex discrimination ordinance, she also wanted to implead the employer to be vicariously liable for her husband's, for his wife's conduct. And the argument failed, but only in the court's view because the argument was not fully addressed. So the court appeared to be willing to hear such an argument. In the second case that I cite, there was a striking out application. In this case, the sexual assault had been committed by the employer's husband, and the plaintiff wanted to make her employer vicariously liable for her husband's conduct. The application to strike out was refused. So my point is, the argument was received sympathetically by the court, and all suggests that we haven't seen the limits of where this argument might go and what sorts of relationships might yet be found to be akin to employment, and how it might provide a remedy in context where one is desperately needed. And this is certainly such an area. Looking ahead, in regard to the akin to employment relationship, I can see how it might have a role to play in the context of the gig economy, where, for instance, Deliveroo drivers or Uber drivers, through their negligence, cause injury to others. Here, I would suggest that these are areas ripe for vicarious liability. We know that the employment has been structured in a way to avoid such liabilities and label the workers as independent contractors or self-employed. But the truth is that the reality is that they probably reside somewhere in between. And so the argument yet may succeed. We have no such case law in Hong Kong, but we do have one that may come before the courts eventually. And you can see that from the South China Morning Post newspaper reference at the bottom of the screen. Perhaps more interestingly is the second limb of the vicarious liability test, and that is the connection to the employment. And we now have seen how the flexibility has been introduced, that it is sufficient that there be a connection between the tort committed and the employment. And the impact in Hong Kong is that, again, an increase in litigation. In fact, before 2002, there were very few vicarious liability cases reported in Hong Kong, and then after 2002, an important year, we see many more being brought. Now, 2002 is important because it follows 1 year after the Lister decision in the House of Lords, which was a decision concerning sexual assault of children. And the case that came before the Court of Final Appeal in Hong Kong did not concern any such facts, but rather what might be called a frolic, a doorman at the Ritz-Carlton Hotel taking a vehicle, one of the limousines, to get food, and driving the car negligently and injuring pedestrians rather seriously. So this is an interesting moment. The Court of Final Appeal determined that the Lister test, although it apparently designed to resolve a particular social problem, could be adopted and applied for all employee torts, including ones such as in the case before it, what I think formerly would have been called the frolic case. So vicarious liability was established on those facts. Justice Bokhari said that the same test should apply for all employee torts because historically it had. And he also commented that probably wouldn't change things much because nearly all previously reported cases would be decided the same way. I believe Justice Bokhari may be still with us. I hope so. He was attending earlier. I'll be interested to, perhaps if he has insights for us. But I was puzzled by that remark because, of course, the case itself might have been decided differently if it was decided according to the frolic principle. An employee who just leaves his employment duties to pursue a personal interest. Now, whether the outcome of the case would have been different is another matter, but I think the reasoning would have been different, might have led to a different conclusion in that case.
Apologies, I think I need to interrupt because time is up already. We're already 2 minutes over time. If you could wrap up.
That is amazing. That is absolutely amazing, Dean. So then I will, if you can grant me 1 minute, I am shocked by that, but that's how things go. If you can grant me 1 minute, then I will scroll through. I will make my points very succinctly. Firstly, when it comes to the connection, the connection to employment criterion, we see an expansion of litigation, particularly in the workplace, concerning assaults committed by co-workers or by workers against the supervisor or supervisors against a co-worker, against a laborer or a worker. And here, if you look at this screen, you will see that there is uncertainty in how to resolve these cases. So we see examples of where there is vicarious liability, there's no vicarious liability, although the facts seem the same. And so it's very difficult to draw a principle out of this line of cases, I suggest, because of the impreciseness of the new test, the so-called connection to employment test. So this is a point I want to make. We have more litigation because of, not necessarily because of the expansion of the scope of liability, but probably more so because of the uncertainty of the test itself. My last slide really concerns another area, employee fraud. Here, another explosion of the case law, probably caused again by uncertainty in what the new test means. Again, Justice Bokhari said the same test would apply for all employee torts, but if later you scroll through this screen, you will see that these cases are in a state of confusion, not uncertain as to whether agency law applies to determine vicarious liability, or whether the close connection test applies, or whether they both apply, or whether we can amalgamate them somehow, as you will see through the screen. So here, my point is, the uncertainty is inviting plaintiffs to sue in this context, and also in the context of workplace violence and assaults, because of the uncertainty in the formulation of the new law. So
thank you, and we need to stop really.
Thank you so much. I will stop.
Thank you very much for this exciting and interesting overview of the developments here in Hong Kong, and I'm sure we'll get more time to talk about these during the Q&A session. Thank you. Our next speakers are Professor Sean Starr, who is Associate Professor and Assistant Dean of Jindal Global Law School, and Executive Director of the Center of India-Australia Studies at OP Jindal Global University. He researches and teaches in the fields of tort law, consumer protection, sports law, and governance, and legal research methodologies. He's joined by Professor Arpita Gupta, who is a professor at law at Jindal Global Law School and an associate dean at the Office of the Dean of Research. She teaches in administrative law, law and torts, and consumer protection, and advanced tort law. The topic is India and Australia, contrasting interpretations of the doctrine of strict liability. The floor is yours.
Thank you very much, Dean, for that warm welcome and introduction, and Richard for your insights so far. Very interesting talk. I hope you can see my screen, by the way. Very good. So we'll get the ball rolling. 20 minutes is short enough as it is, and Arpita and I have decided to divide that in two. So that gives me now 9.5 minutes. So I'll give a brief introduction before giving a little bit of context about, what is the rule we're talking about. I'm sure many of you are across it, but I want to clarify because the term strict liability can, of course, be used in other contexts. And then I will discuss briefly the Australian position with respect to the common law principle of strict liability under Rylands and Fletcher. Arpita will contrast that with the Indian position, and then we'll discuss our findings in that comparison and briefly share our preliminary conclusion because time is short today. So with respect to the rule of Rylands and Fletcher, of course, it's a famous, celebrated principle, but at the same time quite a contentious one. And I've included a brief quote here from a House of Lords case, which I won't read out, but there's plenty of commentaries and judgments which critique the principle which we'll be talking about today. We are referring to the 1868 case of Rylands and Fletcher, and we'll refer to that throughout as the strict liability rule and the strict liability principle. So, of course, since 1868, the concept and the principle of espoused in Rylands and Fletcher has been interpreted, reinterpreted, sometimes even misinterpreted by different jurisdictions around the common law world. And we're going to be talking about how two of those jurisdictions in particular have interpreted in quite opposite directions, and discussing why that might be the case. So broadly speaking, most jurisdictions, including the UK itself, have narrowed that original principle sort of set out by Justice Blackburn in 1868, and then clarified by the House of Lords that in the same case. So the UK itself, as well as Australia, both of which we discuss in our paper, have narrowed that principle of the rule in Rylance and Fletcher, both by narrowing the rule itself and defining what a non-natural use of the land is, and by broadening the limitations and exceptions, thereby narrowing when a remedy can be obtained by the plaintiff. So the exception to this sort of narrowing of this important common law principle in Rylance and Fletcher is India. Indian Supreme Court and also many high courts within India have actually broadened and widened the scope of the rule in Rylance and Fletcher, including, which Arpita will talk about later, the evolution of the concept of absolute liability. So not only have they broadened the scope of strict liability itself, but they have also created a new principle, which we will be speaking on. So the question we've asked ourselves is not only why has this rule been misinterpreted, reinterpreted, evolved, narrowed, etc., but why this divergence between two common law jurisdictions? Why do we have an expansion on the one hand and a contraction, or in the case of Australia, it's been subsumed under the concept of negligence? So I'll try and fly through some of this preliminary doctrinal introductory work, but basically we've set out here what the rule in Rylance and Fletcher is. A person who, for a non-natural purpose, brings something onto their land, and if that something does mischief, if it escapes, he or she may be prima facie liable for any damage caused by that escape. Of course, it's a bit more complicated than that, but time is of the essence. Defences have been established both in the original case, which we've called the traditional defences, and newer defences have been established subsequently, which have narrowed the scope of that original provision. So act of God, plaintiff's own default, act of a third party, and statutory authority. And typically what's happened in more recent occasions is that the defendant has been able to rely on some of these broad defences to escape liability. So I will just list some of the cases here, four or five cases, where the UK itself has actually muddied the waters somewhat, or narrowed the principle of strict liability under Rylance and Fletcher by reinterpreting the concept of fault versus no fault, revisiting and interpreting the concept of what is a natural use and non-natural use of the land. So in Reed and Lyons, ammunitions were considered a natural use, whereas when we look in Rickard's case, which is number 2 over there, basically discuss if something is dangerous and therefore could cause mischief if it escapes, but it's beneficial to the community, it can be considered, it's not a non-natural use. So in a sense, narrowing that original concept as well. So we've got this, this leads us to that jurisdictional divergence, both in the UK, in Australia, and in India. And what I'm going to do now, because I've sort of set out the research question in the last slide, is what is the difference and why is there a divergence, and that we're going to establish that through comparing Australia and India. So in Australia, we have focused, of course, on the landmark case of Bernie Torts, which was a 1994 case, a High Court of Australia case, which, in summary, held that the principle of strict liability is now absorbed by the principle of ordinary negligence. So strict liability, the concept of common law strict liability, no longer exists. It's been absorbed and subsumed by the principle of negligence. So there was a number of justifications by the majority. It was not a unanimous decision. There were two in dissent, which I'll talk on briefly. But the majority talked about how negligence has, of course, expanded significantly since the Rylands and Fletcher case was originally decided in the mid-19th century. And nowadays, or in 1994, the cases that would or should come under the doctrine of strict liability could fall under that evolved concept or principle of negligence in Australia. They also spoke about the narrowing of the scope of Rylands and Fletcher, which I've talked on briefly. And that's important because they talk about the qualifications and exceptions that have evolved both in the UK and otherwise around this principle, essentially making it almost redundant. It has become so narrow that the plaintiffs that would have been able to seek compensation or some form of remedy under that original principle no longer would be able to because of that, the growing exceptions and the muddying of the waters that we spoke about just briefly, just a short while ago. So they basically went on to say that a reasonably prudent person would exercise a higher degree of care. Indeed, depending upon the magnitude of the danger, the standard of reasonable care may involve a degree of diligence so stringent as to amount practically to a guarantee of safety. So instead of saying we no longer have this no-fault strict liability principle, they've essentially said that individuals who are bringing something dangerous onto their land, that if it were to escape, it could harm others, they have such a high degree or level of standard of care that it effectively does amount to a guarantee, as does under the original principle in Rylands and Fletcher. Importantly, the majority also spoke about the fact that this would come under the ambit, or this would be a new special relationship which would attract a non-delegable duty. So in fact, touching on what Richard was talking about before with respect to independent contractors, which is of course a large part of the commentary in the original Rylands and Fletcher's rule, and one of the needs for that principle in the first place, that non-delegable duty should exist in this case, or in any case, where on the one hand we have a party who has control, and on the other hand we have a party who's particularly vulnerable or dependent on the party with control. And they said in the case where someone brings something dangerous onto the land, and if it were to escape and cause harm, that would sort of fall under this non-delegable special duty. So it does now come under, in an Australian context, the concept of ordinary negligence, and we've thrown in Australia this concept of common law strict liability out the window. However, and I'm conscious of time, so I'll touch briefly on the two dissenting opinions here. On the one hand, Justice McHugh sort of focused on a more traditional interpretation of the role of the judiciary, really, and talked about the importance of not simply eliminating and changing a rule that's been around for over a century. It's a well-settled rule, and we shouldn't replace it with a new rule. So there was a large part of this dissenting opinion which focused on the role of judges in evolving and indeed eliminating common law principles that, in Justice McHugh's argument, had the same effect as a statutory law, given how long it's been around as well. Justice Brennan went on to say in his dissenting opinion that it would be inevitable that many defendants liable under that rule will escape liability if plaintiffs are confined to actions for negligence and nuisance. So as to argue that by abolishing the rule in Rylands and Fletcher, there may indeed be people that will no longer have a remedy where they might have otherwise under Rylands and Fletcher rule. A counterpoint to that, and the majority did deal with this, basically saying that the rule has been so narrowed down by qualifications and exceptions that even if under the original rule they might have had a remedy, under the rule as it's evolved, they would not have a remedy under the strict liability doctrine. So that's where we stand from an Australian perspective. So not only have we narrowed the principle, we've completely abolished this principle, this concept of strict liability under Rylands and Fletcher. So that tort effectively no longer exists. It now exists under the banner of negligence in an Australian context, which is a great segue and right on time to go to Arpita to talk on the Indian position.
Thank you, Sean. So the Indian position with respect to Rylands versus Fletcher is vastly different. In fact, the principle of Rylands versus Fletcher continues to be relevant, and it is an independent head of liability in the Indian context. Also, there is an expansion of ambit. For example, injury caused due to motor vehicles accidents and escape of electricity, they are still attracting Rylands versus Fletcher strict liability, which is no more the case in other jurisdictions such as UK. We also see a dilution in the elements of strict liability. So for example, in India, personal injury claims are permissible, and the elements of escape and the defendant's interest in the land from which the escape occurs are given a very broad interpretation in the Indian context. When we look at the case law, we see that the focus is more on potential harm rather than a non-natural use of land that was pointed out by the House of Lords decision in Rylands versus Fletcher. And also, we see that this particular doctrine is applicable to negligence cases also in the Indian context. Now, not only has the ambit of strict liability widened in India, but there is a turn towards absolute liability that Sean was referring to at the beginning of the presentation. And absolute liability in the Indian context is attracted with respect to hazardous substances. This rule was laid down in 1987 in the case of MC Mehta versus Union of India. And the essential elements of absolute liability rule are that absolutely no defense is available. So under strict liability, there are 4 major kinds of defenses available, but we don't have any such defense available for absolute liability. And to explain the concept, any enterprise which is engaged in a hazardous or inherently dangerous activity owes an absolute and non-delegable duty to the community. So this means that such an enterprise has an absolute liability for any harm that is caused because of escape of the hazardous substance. And India is the only jurisdiction in the world where absolute liability is applicable with respect to tort law. So here on the slide, you see the difference between the strict liability and absolute liability as is applicable in the Indian context. Now, let us move on to the next slide, which is the central part of the paper. In this paper, we seek to understand the causes for this divergence in these 2 jurisdictions, and we have identified 3 interrelated factors to understand this divergence. First is the differing emphasis on the elements of the Rylands versus Fletcher rule, which is placed in these 2 jurisdictions. So for example, if we look at pre-1994 decisions, that is pre-Burney Port Authority case in Australia, we see that a generally narrow interpretation has been given to Rylands versus Fletcher, and the plaintiff has lost claims where the court realized that the defendant did not bring the object causing harm on the land, or if the harm was caused because of ordinary use, some sort of ordinary use. And also plaintiffs have not been able to claim compensation with respect to personal injury, or if there was a statutory authority which permitted the act in question. The second set of factors. So now contrasting this position vis-a-vis Australia, what we see in India is generally a broad interpretation of Rylands versus Fletcher. And we actually see the dilution of elements of Rylands versus Fletcher to such an extent that it is conflated with the traditional common law strict liability rule that was prevalent prior to Rylands versus Fletcher rule. Now, moving on to the second set of factors. here we are asking the question whether Rallens versus Fletcher rule is actually serving any need in these two jurisdictions. If yes, what is the need? And this question is very closely connected with the question about development in other areas of tort law, such as negligence and nuisance. So for example, in Australia, the tort of negligence has developed to such an extent that it has subsumed Rallens versus Fletcher-like situations. But when we talk about India, here we see an opposite trend. In India, strict liability is applied even in some negligence cases. So if we analyze the case law, if we look at the judicial reasoning, we see that in many of the cases, strict liability is applied for the purposes of expediency. And it is used as a tool to meet ends of justice. And that explains the flexibility in application of strict liability principles that we see in the Indian context. Now, the third set of factors that are responsible for this divergence between India and Australia relate to the socio-economic context and the judicial culture prevalent in these two jurisdictions. So, for example, in the Australian context, if we look at the application of Rallens versus Fletcher rule, whether in Burney Port's authority case or prior to Burney Port, we see that generally Australian judiciary has taken a very conservative approach in applying Rallens versus Fletcher rule. But in the Indian context, because of the specific instances such as the Bhopal gas tragedy that happened in 1984, which is deemed as the worst industrial disaster in history of humanity, where thousands of people were killed and many more injured, we see a more activist attitude of the judiciary towards hazardous substances. And it was actually this case which formed the background for the development of the absolute liability principle. In one of my prior articles, I have discussed this particular aspect in greater detail. The other difference pertained to factors such as state capacity or the differing state capacity between India and Australia. And here comes the important question of comparative institutional analysis.
So we are running out of time. I think
yes.
We already, okay, sorry.
So we just, this is the last slide, and I would start with the question that we asked in the very beginning of the presentation as to what is the underlying rationale for divergence in these two jurisdictions vis-a-vis Rallens versus Fletcher rule. So we see the answer to this question is a combination of intrinsic and extrinsic factors. And in this particular paper, we have adopted a deductive approach, and we seek to contribute to the academic literature in two areas primarily. First, the literature on jurisprudential divergence, and second, the literature that debates the question on legal certainty versus flexibility. And finally, we also hope to contribute towards debates on legal transplants and comparative institutional analysis. So this paper is very much a work in progress, and we look forward to your comments, questions, suggestions in the Q&A session. Thank you for this opportunity to present. Thank you.
Thank you very much for this thought-provoking presentation. Fascinating information, in particular for comparativists. And I'm sure we'll get a lot of questions during the Q&A session. Our next speaker is Professor Christian Whitting. He is Professor of Law at the National University of Singapore, has published widely. Of course, he is the author of Street on Torts, published in the 16th edition by OUP, Liability of Corporate Groups and Networks, COP 2018, and Liability for Negligent Misstatements, OUP 2004. His current research concentrates on organization liability and tort theory, and he will talk to us tonight about the necessity of strict liability in a corporatized world. Professor Whitting, please.
Thank you, Mr. Dean. Okay, I realize I need to actually open up my PowerPoints first. Sorry, it's been at least a week since I did this, so I'm out of practice already. Thank you very much, Mr. Dean, for the introduction, and good afternoon to everyone, and thank you very much for waiting around at this late stage. So what am I going to be talking about today? The perceived necessity of strict liability in a corporatized world. So my argument is going to be that there are good reasons for imposing strict liability in a corporatized world, and these relate to the amenability of at least some corporate structures to strict liability regimes. So in talking about this, I'm going to start with strict liability and what I mean by strict liability, and have a look at what some of the advantages of strict liability are. And then I'm going to look at how strict liability might apply across 3 different corporate settings involving individual companies, corporate groups, and then finally networks. So my basic assertion will be that strict liability is particularly suitable to corporate structures which involve vertical control. And we see this kind of vertical control or potential for vertical control in corporate groups and individual companies, but we are very unlikely to see this in networks. And indeed, networks demonstrate various limitations of horizontal coordination between independent companies. So that's what I'm intending to talk about, and I'll start with a quote from a science fiction writer named Paul Anderson, and he wrote, "I have yet to see any problem, however complicated, which when looked at in the right light did not become still more complicated." That might be a taste of what is to come in these PowerPoints. Okay. So let's start off with strict liability. In talking about strict liability, I follow the definition that Peter Kane adopts. So we talk about liability, which is regardless of fault. We can't say that this is no fault liability, because in fact there's no inquiry into fault. We don't know whether it was present or not, so as to justify liability. In my view, the focus of strict liability is with what we could broadly call unwanted outcomes. And we see that strict liability arises in predefined circumstances, and indeed many of these have been mentioned already today. So we can talk about, for instance, activities that are dangerous in nature. We can talk about non-delegable duties which have been applied in school and hospital contexts. We can talk about product liability, liability for defective products which cause injury, although there are arguments that I think are correct that in fact this is a very compromised type of strict liability because of the presence of the development risk defense, and of course we can talk about vicarious liability. So those are the circumstances generally in which we see strict liability being imposed. What are the advantages of strict liability? Well, I think that we find that strict liability generally is justified in part because it's placed upon those companies or those persons who are best placed to prevent injury. Okay, liability, in other words, is imposed upon, or responsibility is imposed upon the parties in the superior positions, such as schools, hospitals, and employers. Another advantage is that there's no fault escape mechanism. Responsible parties therefore know in advance, they know beforehand that they are responsible and that they're going to be liable if unwanted outcomes occur. And I think that this is extremely important because it means that these are the parties who are expected to plan their activities properly and to take proper precautions. There's very little doubt about this type of prospective, forward-looking responsibility. We can also note with respect to corporate defendants that there have been arguments that corporate defendants are themselves in a very good position to implement preventive measures, for instance, because of factors that I'm now going to be talking about. Okay, so I'm moving from a brief look at what strict liability is and some of the advantages to the context within which we might think that strict liability should be applied to the various types of business organization. I start with the company. I'm working on a paper at the moment looking at the nature of the company, and I tend to agree with Belinfanti and Stout that there's something special about the company, that we can call it a system. I can't really look at a full explanation of what a system is today, but basically we're talking about a type of business organization with various elements, here bounded by the separate legal personality of the company, and these elements work towards common purposes in a coordinated way. It's important to stress that the company is a bounded entity. It is a fixed and stable entity, and we can contrast this later with the corporate network. Within each company, there is the potential for vertical control through the managerial hierarchy. Okay, so what this means is that senior managers can issue commands to middle managers, to employees, and to others, so that their will in fact be carried out. This is possible, and it sometimes happens, but ordinarily control is not exercised in especially larger companies in this way. Control is actually exercised indirectly and therefore more efficiently through various policies, procedures, routines, and cultures. And essentially they all are there to ensure that the company pursues its purposes effectively, that all of the elements are properly coordinated. So I want to suggest that these features of the company do make it amenable to strict liability. Responsibility can be placed on the company so as to take advantage of the vertical power relation and the managerial hierarchy in order to plan activities and to prevent wrongs from occurring. And indeed, these features make it little wonder, in my view, that strict liability is quite prevalent when we come to the individual company. It's prevalent, for instance, in vicarious liability and product liability. Okay, and we might notice another thing, which is somewhat of an aside, but here we talk, of course, about externally imposed rules, rules that are imposed like regulatory, criminal rules from without on the company. And of course, in each case, they need to be transposed internally into those things that I've already spoken about. They need to be internalized in terms of policies, procedures, routines, and cultures. And it's helpful to know that in the United States, there is something called the care mark duty, which in the corporate context is imposed upon directors and senior managers of a company, which ensures that if there are failures to put in place relevant compliance regimes, okay, to ensure that the company does comply with external rules. If there's a failure to monitor compliance with these external rules, that it's possible for those directors and senior managers themselves to be held liable for any damages that have to be paid out by the company to third parties who are injured. And I'm just going to be making an argument in my paper that this would actually be an extremely important mechanism for a jurisdiction such as the UK to adopt. But I won't go further into that now. Let's turn to the second type of business organisation that's on the agenda today, the corporate group. And what I want to suggest is that the corporate group is also amenable to strict liability rules. And this is despite the standard picture of the corporate group, right? The standard picture of the corporate group will place particular emphasis upon the separate legal personality of each of the companies in the group, and also upon the limited liability of the parent company. So of course, the picture involves the idea that each company is essentially an independent party in the world of commerce. So each is responsible for its own operations, it's responsible for its own failures, and it's responsible for its own liabilities. So these liabilities prima facie should not be extended to other companies in the group. So in a recent paper, I've tried to argue against this standard picture, once again, portraying, in this case, the corporate group as a system. Okay, so it's a system in the sense that you've got multiple different companies, the elements within the group that once again are bounded in nature. In this case, they're bounded by equity relations, and these companies pursue group purposes in a coordinated way. So corporate groups, importantly, also feature this vertical power relation. Okay, so we can see, for instance, that the parent company will do such things as structuring the business relations within the group, often structuring the group into divisions, allocating business functions. So this would include, for instance, making decisions to produce risky products or undertake risky activities. The parent company would appoint senior divisional managers and so on. So as such, once again, we see the potential for vertical control through a managerial hierarchy. Senior managers within the group, usually, of course, located in the parent company, are able to issue commands to middle managers, for instance, at second tier companies within the group, to employees throughout the group, and so on. Okay, so that is a power that is there and available for use, but once again, we find that it is not particularly frequently used. And that's because corporate groups, most corporate groups, especially the large ones, are decentralized in nature. They have decentralized operations. Each subsidiary company is going to be undertaking a function. Each needs to coordinate with other horizontally related subsidiaries and so on. Many of the managerial functions in the group are actually delegated to a second or even a third tier level. So how does the parent company within the group actually exercise control? Well, my research indicates that it exercises control in rather the same way as in an individual company. This is through policies, procedures, routines, and cultures. Okay, so in the end, I think we can say that each company operating in the group, in terms of what it does and in terms of its failures, is influenced causally by the parent company and decisions that it makes. So all of this, I think, makes the parent company amenable to strict liability. But strict liability is now rarer in this context, that is, in its application to corporate groups. We do see product liability rules, of course, being applicable to group companies. And I've made certain arguments that strict liability rules could be extended even further within particular circumstances, especially where there are risks of physical injuries. And what I mean by this is risks which are created at the subsidiary level. However, at the moment, this is not where we are in terms of liability rules. Generally speaking, the default liability of the parent company in the group is negligence based. Okay, so there must be a failure to take care in the parent company itself, which has a causal connection to any injuries which are caused at the subsidiary level. So my argument essentially is a normative one with respect to the application of strict liability in corporate groups. Lastly, we come to business networks, and these are very different forms of business organization from the ones that we've just discussed, because the structures in place are not vertical, they are horizontal. They're constructed upon, of course, contracts and cooperation between formally independent parties. So what this means is that some of the features that we have previously talked about are not present. So there are no established boundaries. Networks form, dissolve, and reform continually. There are no common purposes. In fact, there are inherent conflicts that arise between cooperating companies here, and each network partner company has a separate managerial hierarchy. There's no vertical control. So it's a very different picture, but the question might be asked in at least a hypothetical way about whether strict liability might be relevant here, or whether other liability rules might be relevant so as to extend liability from injuring parties that might become insolvent to their network partners. Now, this is much more difficult. Nevertheless, we can say that, again, product liability rules, strict liability rules of this kind do apply, and what they do is they channel liability to manufacturers, although the concern is very much for the activities of those network companies that are within the jurisdiction, and certainly there's no responsibility for setting standards beyond the jurisdiction, and this is relevant to something that we're going to be talking about in a moment. So that's the type of strict liability that does apply currently. There have been arguments by writers on corporate groups such as Chowdhury and Petron, who've argued for a form of vicarious liability so as to create a more general type of strict liability within corporate networks, and they would say that this should happen in cases of close integration between the parties and where there have been attempts to externalize liability by the defendant upon its network partner. So indeed, there is some strict liability, and there are calls for further strict liability in this context, but I am very dubious about the prospects of strict liability beyond products liability succeeding. Now, here I want to talk about another important proposed law which would apply in the network context, and that seems to be relevant to us as tort lawyers, although it's not, the proposal is not for strict liability. The significance is that the proposal is for a form of horizontal liability. So I talk here about the proposed EU directive on corporate sustainability due diligence. It seems to be of interest to us as tort lawyers because it's going to, if it is passed by the European legislatures, it is going to operate in circumstances that are very closely related to tort law. So the directive would address adverse human rights impacts arising in circumstances including raw material sourcing, manufacturing, or waste disposal. It would attach to, essentially, I'm summarizing here, medium and large size corporate groups and companies, which would then have certain responsibilities which are horizontal in nature. So these bodies would have to do such things as identify actual and potential adverse human rights impacts in the supply chain or the value chain, seek contractual assurances from direct and even from indirect network partners to seek compliance with nominated standards, and even take corrective action with respect to adverse human rights impacts caused by direct and even indirect network partners. So these impacts will in many cases take place outside the EU. This is what is contemplated in low regulation jurisdictions. So no doubt the desire here is an admirable one. The desire is to ensure improved safety and other practices in low regulation jurisdictions. What sort of liability would it be? Well, as far as I can tell, the directive isn't extremely clear about this, but it seems that there would be liability, potential liability in corporate groups and companies where they fail to act reasonably. They would be open to official sanctions and also a potential civil liability. So again, this is just an illustration of a potential type of extended, and in this case, horizontal liability, which might become law very shortly in the EU. But I have severe doubts about whether this type of horizontal liability is proper and would be effective. So I can basically summarize my doubts in this way, so that of course we've seen that there are very different structures in corporate groups and companies on the one hand, and in networks on the other. There's no potential for top-down control, and many other sorts of legal rights, such as rights to inspect and monitor, etc., are not present. We could also worry about the potential for this type of horizontal network liability, reducing the incentives for those companies that are, for instance, in low regulation jurisdictions to take their own responsibility. We could even potentially worry about the incentives of the lawmakers in such jurisdictions to themselves develop appropriate laws and standards for their own circumstances. In the end, I think that there is the potential that this type of horizontal liability will be very ineffective and very inefficient. There's a big debate going on at the moment within the European institutions and within the European legal scene about all sorts of things, including the potential cost that would arise to EU corporate groups and companies from having to comply with these sorts of obligations. Anyway, these are just a few snapshots of my research in this area, and I'll be happy to consider questions later when that's appropriate. Thanks.
Great, thank you very much for a great talk, and also for keeping or staying within the time. Our last speaker is Professor Paula Gilliker. She's Professor of Comparative Law at the University of Bristol. She's also the former chair of the British Association of Comparative Law and a former honorary secretary of the SLS, and is now a trustee and vice president-elect of the Society of Legal Scholars of the UK and Ireland. As most of us know, she has published extensively on comparative private law and topics and the law of obligations. Her recent publication includes Codification, Consolidation, Restatement, how best to systemize the modern law of tort. And I'm sure that this paper, which was published in 2021 in the ICLQ, has inspired a lot of the talks also today. At least a lot of the issues that were mentioned are probably covered by this paper. But without further ado, over to you, Paula.
Thank you very much, and thank you for the invitation to speak here today. I'll try to keep to time, not least because you've had a busy day. So fantastic papers, it's been a great event, and it's good to see so many people here today. But I do want to talk about a theme which hopefully brings a lot of what we've covered today together. And it's looking at particularly in tort law reform from a particular angle. And this is in relation to smaller jurisdictions. And I'm using vicarious liability as an example to get us to think about how we modernize, reform, develop laws. It's about legal development, which is the kind of thing I was thinking about with the ICLQ piece. But again, the particular challenges for smaller jurisdictions. And you can see on this particular first slide, snapshots from 4 smaller jurisdictions. And you can see that they vary a lot. They are, I'll leave you to guess where they are. I think most of you will be able to work them out. But although they share similar population sizes, you can see that there's a great diversity in how they actually operate. But what they do have in common is population size. And this is, as we can see, if we look at Singapore, Hong Kong, and also if I have time, which I suspect not, look at Ireland, because this is something that brings smaller jurisdictions together. I'm looking at smaller common law jurisdictions, and I'm looking at these common law jurisdictions in relation to the law of tort. And this is where it gets interesting, of course, because tort law is mainly by cases. We've talked about some statutory intervention, but as Rick said, in relation to Hong Kong, for example, you're seeing mainly cases coming through. And in relation to a system that relies on case law development, size does matter. It matters in terms of the number of cases going to court, the number of courts you have hearing cases, the number of case reports, the amount of litigation that you have. And so one common characteristic of the smaller jurisdictions I'm looking at today is that common law jurisdictions dealing with problems of tort law and actually trying to develop it through a system that is essentially predicated on having a volume of cases that will enable legal development. So what do you do if you've got limited case resources? And this has a knock-on effect also with the secondary material you have. There's an interesting study by William Twining and Jenny Uglow in 1981, and they noticed the economic and practical difficulties of small market law publishing. So it's difficult to find materials just on your specific jurisdiction. It's difficult to get a market for a textbook, particularly ones that are published on a regular basis. It's difficult to get funding for monographs. So you have, in a sense, a resource issue. You've got limited cases, limited academic literature just on your system. And if you have fewer universities, you have fewer legal scholars, so fewer academics that are working particularly on your system, domestic system of law. So what do we do about that? What can we engage in as a way of encouraging legal development when we are resource light? And this is where you can see, and it's interesting, I've been reading articles on law and economics, and the law and economics arguments are quite strong, that the most efficient way to deal with this is to look overseas, to look to other jurisdictions, larger jurisdictions, which have the volume of cases, that have the literature, that have the discussion, that can actually give you inspiration for legal development. So the question then becomes, which systems do we use? And again, I can dig deeper in this in the paper, but it's interesting to see that what seems to motivate jurisdictions in this respect is looking for similar systems, so the same legal family. So focusing, for example, if you were looking at Hong Kong and Singapore, at systems that have a common law background, that have clearly dealt with questions of law in more depth, more detail. Accessibility, practicality is an issue, that they're easily accessible, but also accurately reported and put it in a way that can be accessed with ease. But also, and again, there's been a lot of comparative law literature on this, when choosing those systems, they're not necessarily objectively the best system, but systems that have esteem, that are regarded as authoritative, that have, in a sense, a reputation that makes them worth consulting and indeed triggers the idea that they should be consulted. So we're looking for systems that often have a shared history, a common mode of thought in legal matters, similar institutional backgrounds, similar use of legal resources, and also an ideological background does seem to be relevant, looking at systems which seem to share common values. But also the historical element is obviously relevant here. As I say, I'm looking at jurisdictions such as Singapore, Hong Kong, and Ireland. But clearly the legacy of the Privy Council, the legacy of having a common law background, similar older historical sources, is something that does make the law at least relevant and accessible in the sense that it's clearly understandable in terms of the way it's portrayed. But we do need to be extremely careful here. We need to think of what are the benefits of looking at other systems for inspiration to deal with the smaller jurisdiction problem, but also look at some of the negatives, the difficulties of this. And even comparative lawyers such as Basil Marcasinis, that very much advocates looking at other systems, says you do need to be careful. And I've listed some of the positives and negatives on the slide, but clearly issues such as loss of autonomy, national identity, misleading legal transplants, not understanding the inherent conceptual elements that draw it to one system and just taking it at first hand, different political, economic needs, and also, as this paper will indicate, the problems of bringing in laws that actually are not particularly clear, coherent, or subject to change, and then subsequently finding that they've changed. So bringing in uncertainty, doctrinal problems that are still problematic in the jurisdiction you're borrowing them from. And Jörg Fedke's quote, I think, is quite an interesting one to frame this discussion. Borrowing is easier, he states, in areas of law which could be described as more technical in nature, whereas the outcome of a legal transplant becomes far less predictable when policy considerations and fundamental values such as human rights come into play. So one big question we need to think about is which of those is tort law? Do we see it as technical law, or do we see it as value-laden or policy considerations? And it may be that the law of torts is so disparate that there's no one single answer to that. But it does provide a framework for thinking about how we deal with this. So Rick has excellently spoken about vicarious liability, and I think this is a really interesting area because it is an area where, as Rick has stated, the courts in smaller jurisdictions are looking at the larger jurisdictions. So they're looking at UK law, they're looking at Canadian law, and that is bringing in inspiration to actually frame dialogues, as Rick said, encourage litigation, stretching the law, revisioning the law in a way that is inspired from these larger jurisdictions. This, of course, the theme of this session is about strict non-fault-based liability, and vicarious liability deals with relationships giving rise to vicarious liability and finding that relationship, there's a connection that links the relationship and the act of the tortious act of the usually employee. And what we have seen is that when we look at it globally, the relationships that give rise to liability, typically the employment relationship, employment's changed. We have Uberization, we have the gig economy, we have different ways of framing what we mean by workers. So in an evolving global economy where ideas about workers have changed, then a legal doctrine that looks at the worker, the employee, as part of that test needs to be rethought. It needs to be modernized. So we've got tensions coming through the changing work practices. We've got pressure to perhaps extend vicarious liability more generally to intentional torts, which could exist from a fight in the workplace to sexual abuse, and abundant case law coming from these larger jurisdictions, which courts are looking at. And again, we're seeing it's an area where there's a lot of comparative law interest, and I've cited two excellent comparative law monographs by, you may be familiar with, by Anthony Gray, who's based in Australia, and Christine Boyerman, who's Australian, based in England. And again, showing that this dialogue between other common law jurisdictions is very, very strong in this area. I probably don't have time to go through these, but we can see that, just for reference, UK developments, so in particular, the Catholic Child Welfare case in 2012, followed by Cox and Arms expanding the notion of what we mean by the employment relationship. And then 2020, the Supreme Court saying, well, have we gone too far? Do we need to slow this progress down? So in 2020, again, a sense that we need to slow this process down. And of course, when we look at cases in Hong Kong, what's interesting here is the Privy Council Hong Kong case of Lee Tang Sang, which is using authority from the English courts as a way of looking at the relationship test. But the Privy Council there specifically picking up an article by John Rear in the Hong Kong Law Journal saying we need to think about employment in the building industry from a Hong Kong perspective. And again, if you look at these cases, and I haven't got time to do so, what we do see is Hong Kong issues coming through. So casual labour does seem to be the issue that's motivating the courts and forcing them to think how this actually works. What is this relationship between independent contractors for whom vicarious liability does not apply and employees? How broadly do we take it? Does it extend to akin to employees, as it has in the Cox case? So the Cox case is being discussed, and clearly the issue there is to what extent the treatment of casual workers in Hong Kong should mirror that in the UK. One thing we do see is, in a sense here, some of the UK law being what I would call in the paper a disruptor, actually saying, okay, this has been very flexible, we're really expanding this in a perhaps less than coherent way. And it's left for the domestic law to say, well, what do we do with this? And what we are seeing coming through, and we see this in all the jurisdictions in this paper, is a more cautious approach to these approaches, because what we're seeing is development in the UK that's being criticised as out of control, too broad. And so bringing these authorities in, but at the same time expressing caution and expressing concern as to how far this can go. So again, what's interesting in Singapore in particular is the Ing Huat Seng case of 2017 that adopts a very cautious approach to this employment relationship test and is actually welcomed by the UK Supreme Court in the Barclays Bank case in 2020 as essentially a voice of reason. This is the way forward. We need to be more cautious. So in a sense, the transplant of the idea to Singapore has been flipped in that the application of the law in relation to the employment relationship in Singapore is influencing the UK Supreme Court to adopt a narrower approach. And again, Ireland, it's very similar debates going on. Now, the close connection test is really interesting because this is where there's been a lot of criticism of the UK law. Broad approach adopted in the Catholic Child Welfare case. Mohammed, I would say ridiculously, but some would say justifiably, generous approach. And then in the 2020 case, gone too far, let's go back to a more traditional approach. It has to be a close connection, not a sufficient connection, as was discussed in Mohammed. In Hong Kong and Singapore, you see the court struggling with this. They get the message that we need to go for a connection test. They follow that, they follow Mohammed. And then of course, there's concerns that it's going too far. And again, the message coming through is caution. Think about the justifications, think about how to deal with this. There's also risk-based reasoning, and David Tan's work on this, I think, is excellent. Singaporean courts are more willing to embrace this idea of risk-based reasoning. Mixed views from my reading of the Hong Kong law, some of it taken as read, are not really engaging in the critical analysis that risk-based reasoning, I think, really requires. And it splits the Supreme Court in Ireland in O'Keefe and Hickey. Half the courts thinks it's a ridiculous idea, the other half sees it justified on the basis of Canadian and UK law. Hickey and McGowan tipping in favour of the connection test, but again with caution, and certainly talking to Irish scholars and other scholars working in this law, again, the idea is that the various claimants case of 2020 is likely to be favoured in the jurisdictions with its more cautious approach than the wider approach. So what conclusions could we draw from this very quick, very brief example? But I think it is interesting the extent to which we are using sources from other countries in our legal development. When we think about tort law reform, any comparative lawyer would say, if I want to reform the law, clearly I have limited inspiration, but there will be inspiration elsewhere. So why aren't we looking at it? And indeed, that's something which we should really do. But we do need to think about what we are bringing into our system and how it will fit in. In a sense, what's the value added if we're looking at these new imports? And you can see a quote from Lord Phillips of the UK Supreme Court, who is sitting as a non-permanent judge in the Court of Final Appeal, giving a lecture on vicarious liability. It was given live at the University of Hong Kong published in the Hong Kong Law Journal, which emphasizes the interrelationship between our common law jurisdictions. And the issue for smaller jurisdictions is, in a sense, you have to look at these other systems. You're not going to get enough resource from your own system to give you what a case law system needs. It's a case law system is hungry, it wants cases. If you haven't got them domestically, you need to look elsewhere. And it can do lots of good things: inspiration, gap filling, giving you justifications for your reasoning, and importantly, modernizing the law, bringing it forward, taking in a global market ideas forth about the changing nature of the societies in which we live. But care does need to be taken. We need to avoid ill-suited legal transplants. We need to think about our domestic concerns. We need to avoid path dependency, another thing that comparative lawyers like talking about, the trigger that you just look at jurisdictions because those are the ones you already always have, as opposed to thinking what are the best jurisdictions to give coherency. And the big problem with vicarious liability is if the law isn't coherent, if there are active doctrinal debates about the scope of strict liability, then how do you deal with those as a smaller jurisdiction? So my answers would be that the approach taken by the courts, which is cautious, care, is the right one. You do need to think very carefully about this. If you want to gain esteem, I think should be earned. It shouldn't be there seen as a matter of right. Largest jurisdictions can and often do get it wrong. We see that particularly in relation to policy-based areas of tort law, where there are clearly huge debates that need to be discussed. And the more technical the law is, perhaps the safer it is to bring it into the domestic system. But it does need to be adapted. And again, the literature coming from comparative law is that adaptation is the key, working out how this can benefit the system. And certainly the view is that at least you need to make an informed choice about the alternative rules that you want to adopt. So again, there's a strong law and economics literature on this about the most efficient way of engaging legal development in smaller jurisdictions. So my conclusion would be, while borrowing has real benefits for smaller jurisdictions seeking to engage in tort law reform, we do need to think about its validity and adaptability to domestic needs. So hopefully I will explore this in a larger article, but I think it's really interesting to think about how we engage with tort law reform, how we engage as a broader community in Asia and beyond, and think about the different types of tort law in which we engage and the challenges they raise for us in terms of achieving the best system for our own law of tort, which is best suited to the domestic system in which we operate. Thank you.
Thank you very much for, again, a very fascinating talk with lots of thought-provoking ideas and points that you've made. We have now about 15 minutes for, 10 to 15 minutes for questions. We've already received a couple of questions. If members of the audience have additional questions, please chat them in so that I can bring them to the attention of the speakers. Thank you very much. Let me start with a first question for, let me see, where is it? For Rick. Sorry, it was not this one.
I'm here.
Yes, but I need to find the question because I've received so many questions that it's difficult now to identify that one. Okay, here it is. Do you think vicarious liability is an area where consistency between common law jurisdictions ought to be maintained, if at all possible, or can there be a scope for regional, local variation of the relevant principles to take account of different social conditions?
Thank you for that question, and thanks to the presenter of the question. I have thought about that a little bit. I wonder, in a more general sense, the degree to which, say, a place like Hong Kong or a smaller jurisdiction, as Paula has discussed, requires this sort of participation in a consistent way with the broader common law world, or whether in vicarious liability, for instance, there is a need for a tailored approach. And in the context of Hong Kong, I think that, yes, it very well does call for that, because the adoption of a what I would call an imprecise test that replaces one that was equally imprecise, but we're still in the same place. We're not getting any further ahead. But when we consider that that the test was adopted in a social context in a society that's quite different from Hong Kong's, then one would want to really proceed cautiously and really consider the purpose of vicarious liability, its objectives in the context of that community. So I would think that there is a case for that in vicarious liability in Hong Kong.
Thank you. Next question for Sean and Arpita. A fascinating comparison between Australia and India with lots of interesting points. What is the methodological justification for comparing just these two countries?
Arpita, do you want to have a go at that?
Sean, you go ahead. We've discussed this question this morning only.
Yeah, it's a good question. We discussed it amongst ourselves, and part of the question is where do you draw the line in terms of we could compare every common law jurisdiction. Scotland, South Africa have adopted a similar approach whereby they've effectively moved Rylands and Fletcher aside. We do discuss UK. So effectively, in some respects, we compare UK, Australia, and India. And why those two jurisdictions? Because they adopt in the majority judgments, in many respects, both identify shortcomings of the Rylands and Fletcher principle and deal with them in completely opposite ways. And that's what we want to get to the bottom of in terms of our discussion. So we do, in the preliminary part of our paper, identify that we could have compared all common law jurisdictions, but and there are limitations of only discussing two, but we discuss these two because of their completely divergent approaches.
So adding on to that, we also discussed that the different socioeconomic context between the two countries. So we need to take into consideration before thinking in terms of legal transplants. So that is another part of the answer that I wanted to add on to. Thank you.
Thank you. Two questions for Christian. I enjoyed all the presentations. I have two questions for Christian, says Joel. First, you correctly note the care mark duty of directors and officers. In your opinion, is the Marchant ruling, which imposes a duty to continuously monitor, too strict or not? First question. Second question, in Delaware, directors and officers do not have to pay personally for violations of the duty of care unless they engage in bad faith or disloyalty. They can be covered by D&O insurance, etc. If they do not have to pay because there is no good faith or loyalty issue, how can directors and officers be incentivized? Why would care mark duties ensure good conduct?
Okay, thank you very much for those questions. So I think the Marchant case was very interesting, a kind of a watershed, because prior to that, care mark was not taken very seriously. The Delaware courts themselves seem to stress that the circumstances in which there would be liability were going to be essentially extreme. So there would have to be complete failure either to put in place the compliance systems or complete failure to monitor. And it seems that events, right, in the corporate world have motivated the US courts, the Delaware courts at the moment, to move on from that and to make the duty a little bit more proactive. So this is now being explored in the case law, and we're not very sure at this point how proactive that means that directors and senior managers have to be. In terms of the directors and officers insurance, yes, insurance is always the bugbear when it comes to liability. So, well, what can I say about that? Unless it's made unlawful, it's there and it's going to cover many types of default. Okay, now what many commentators would say is that the pecuniary liability is often besides the point, because any director who is made liable for breach of caremark will become almost infamous, seeing as there have been relatively few successful cases. Any successful case against a director or senior manager would be headline news. So and failures of that type, right, which in the past at least have been complete failures to exercise managerial oversight, would probably mean that a director or perhaps a senior manager would have little future in the corporate world. I think that's the answer to it. But absolutely, the insurance is a problem in this area.
Thank you. One question for Paula, actually two questions for Paula. The first one, could you please identify some technical laws which might be easier to be transplanted? And if I may add my own question to that one, you have pointed out all the difficulties encountered when transplanting law from one jurisdiction to another. But are there really differences between the success or failure of transplants when you compare small jurisdictions that you have discussed and the larger jurisdictions? Is there any difference?
Really good question. One of the issues, and we've seen this in relation to the harmonization projects in Europe, is the extent to which you can have technical law that's easy to harmonize. And for example, contract law is always given an example of something that's more technical. And yet when we drill down into contract law, particularly consumer contracts, there are still policy elements there. So I think we had to see technical as a sliding scale. Is it something that is like negligence, what is reasonable, the reasonable person, which is clearly not technical, to some torts that, for example, battery, that it's immediate and direct, which is perhaps more technical law. But I think one of the problems we have with tort law is it's a law of civil wrongs, which is one reason why harmonization at the European level has always focused more on contract than tort law, because I think tort law is about people, it's about our societies, it's about the values we have that underlie why we impose burdens on citizens towards each other. And therefore it is something we need to think about very carefully. The reason I think there's particular dangers of transplant to smaller jurisdictions is, in a sense, you haven't got the opposition. So in larger jurisdictions, if you bring in, say, a US case, there's lots of domestic cases there, and if it doesn't fit, it's very clear it doesn't fit, or you're doing something revolutionary. But what's interesting in looking at some of the cases in Singapore and Hong Kong is that they're looking at cases coming out the UK, and they might mention one Singaporean case, one Hong Kong case. So you've got 3 UK Supreme Court decisions and then one Singaporean case to balance against. So if those cases coming out from outside are going to be received without due caution, and you've only got one domestic decision to, in a sense, balance it out, there's a danger of a clear distortion. So I think, again, it's lack of resources. And also, I mean, again, one thing we do need to think about is we've talked about in comparative law terms, the white commonwealth, that we're looking at systems that are particular systems in the common law and not looking at more broadly. And again, I think we do need to be a bit more proactive in thinking of what other systems we look at. So again, it was very interesting looking at Singaporean law in that they were referring to Mingan, a case from Hong Kong, which Rick talked about in his paper, which again is a very interesting case, talking about how we want to develop the course of employment test, to what extent we use the close connection test, and giving a practical example. So again, perhaps using more comparators within Asia might be a step forward than just looking back to traditional partners in the sense that perhaps they're closer to our own national concerns.
Thank you very much. We are running out of time, but I would like to, I have one more question for Christian, and then I'm afraid we need to close, and I apologize for all the other, participants who have sent in questions. That one question is to hold a parent company is strictly liable for a tort directly committed by its subsidiary company. Do you think the party should bear the burden, which party should bear the burden of proof to establish the vertical control of or internal managerial influence on the subsidiary company?
Yeah, okay, that's an interesting question. I'm not sure that I've ever explicitly thought about it. Right. What I've done is I've essentially taken a survey of the organisation literature and come to certain conclusions about how control is exercised within the company, within the corporate group. I think that in a sense, any liability rule is going to be severely undermined if any claimant who seeks to take advantage of it would need to prove this kind of control or indirect control being present within a corporate group. I mean, I would say that this should largely be given judicial notice because one of the usual advantages of a strict liability rule, for instance, in vicarious liability, is that there is no need to actually become familiar with the internal workings of, let's say, a company, in this case in the corporate group, because of the severe costs that would be incurred in obtaining evidence. So I would be very reluctant to say that it should be any part of the case of the claimant to have to prove the existence of this type of internal control. I think it should just be taken as noted.
Thank you very much. As mentioned, time is up. It remains for me to thank all the speakers for really fantastic presentations and for a great discussion. This is the end of this plenary session. Many thanks to everybody for joining at such a late hour.